We're going to have some fun today. Well, at least fun as far as I'm concerned. Well, we'll see what you think in a moment, but before we do, the Daily Mail, Trump hush money trial judge, it's a mouthful, Juan Merchan warns parties of incriminating Facebook comment the day before the verdict. By Sarah Ewell Weiss, the judge in Donald Trump's case sent a letter to the ex-president's lawyers and the prosecutors warning of an incriminating social media post that went up before the jury reached its verdict in this historic case, they write. The 12 New York jurors found Trump guilty and blah, 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 blah. But in a letter to Trump's lawyer, Todd Blanche, prosecutor Joshua Steinglass, and the other lawyers in the trial, Judge Juan Merchan brought to their attention a comment posted on the United Court System's public Facebook page. It reads, quote, "My cousin is a juror and says Trump is getting convicted, emoji. Thank you, folks, for all your hard work." See, it was always a setup. Phony jury. Merchan wrote in his letter that the comment was posted on May 29, the day before the jury found Trump guilty from a user, Michael Anderson. It was posted in response to oral arguments in the 4th Department of the Appellate Division unrelated to the trial. The incriminating post raises questions about one of the jurors did in fact discuss the case with others when they were not allowed to. So there's another basis for appeal. Now, you want to have some fun? Let me put it to you this way. I want you to sit back. I want you to relax. Class begins now, and you are now going to know more than any of the legal analysts on television. That's fun, don't you think, Mr. Producer? I don't know. I think it is. All right. If you have kids in the car, tell them, listen carefully. Don't fight in the back. Stick with us. If you're at the dinner table, first we begin at the beginning. And what I'm going to explain to you is an area of the law that most lawyers do not comprehend because they don't practice in this area. But they're more than happy to comment on it. And you might be surprised at my take on some of this. So I open my book, Men in Black. And I turn to page 166. This was my first book ever. And by the way, Donald Trump has raised almost $300 million since the verdict. On December 11, 2000, the Supreme Court held a hearing on the Florida court's latest action. That would be the Florida Supreme Court. On December 12th, by another 5-4 margin, the Supreme Court held that the Florida court had violated the Equal Protection Clause of the U.S. Constitution by ordering statewide manual recounts with different standards in the various counties. See, the court realized that the effort here by the Supreme Court, which was all Democrat, but the chief judge there said, no, this is wrong. But nonetheless, 7 members, 4-3, that they kept allowing recounts on different standards, particularly in the blue counties in South Florida, to get Al Gore a few hundred votes to push him over the edge. On December 12, 2000, by another 5-4 margin, the Supreme Court held that the Florida court had violated the Equal Protection Clause of the U.S. Constitution by ordering statewide manual recounts with different standards in the various counties. In its decision in Bush versus Gore, the Supreme Court stated the following: the right to vote is protected in more than the initial allocation of the franchise. Equal protection applies as well to the manner of its exercise. Having once granted the right to vote on equal terms, the state may not, by later arbitrarily and disparate treatment, value one person's vote over that of another. The recount process and its features here described as inconsistent with the minimum procedures necessary to protect the fundamental right of each voter in the special instance of a statewide recount under the authority of a single state judicial officer. When a court orders a statewide remedy, there must be at least some assurance that the rudimentary requirements of equal treatment and fundamental fairness are satisfied. Remember the Chads fight? Well, the standards were loosened for the Democrat counties. The manual recounts were halted, and the frenzy of litigation initiated by Gore was ended. Gore made his long-delayed concession speech the day following the U.S. Supreme Court's ruling. And what the court did, ladies and gentlemen, is it stayed the Supreme Court's action. It stopped the continuing vote count. It issued its ruling within 48 hours. And at the end, as a result of what they did, the Electoral College votes in Florida went to George W. Bush. It is clear that the three judicial originalists on the U.S. Supreme Court, Chief Justice Rehnquist, Justices Antonin Scalia, and Clarence Thomas, two great justices are now gone. John Roberts is no Rehnquist. Were not able to assemble a majority on the court on the straightforward question of whether the Florida Supreme Court usurped the authority of the Florida legislature in ordering standardless manual recounts past the federal deadline. Article 2, Section 1, Clause 2 of the Constitution specifically empowers state legislatures to determine how electors are chosen, and we've been through that. The Florida Supreme Court repeated manipulation of state election law procedures and rules supplanted the legislature's authority under the federal Constitution. I've said this over and over again. Those three justices wanted that to be the basis of the decision, but they couldn't get two more. And so 7 justices, what we call per curiam opinion, unsigned, settled on the Equal Protection Clause of the 14th Amendment. Nevertheless, the actions of the Florida court were so egregious that a majority of the U.S. Supreme Court believed something had to be done to address it. While 5 justices signed on to the U.S. Supreme Court's decision based on Equal Protection Clause violations, 2 additional judges actually embraced the equal protection argument, even though they voted in the minority for other reasons. I believe Rehnquist, Scalia, and Thomas obviously tried to make the best of a bad situation, unable to convince Justices Sandra Day O'Connor and Anthony Kennedy to overturn the Florida Supreme Court on Article 2 grounds. That is, that they defied the power of the state legislature under the federal Constitution. Stay with me. This all makes tons of sense. Still, the best decision would have been no decision. What? The best decision would have been no decision. Stay with me. You got to hear the whole point. While the U.S. Supreme Court's motive was understandable, reining in a lawless Florida Supreme Court, it may well have unleashed future election challenges based on the Equal Protection Clause, involving voting machines, voting procedures, the tabulation of votes, the qualification of candidates, and so forth. As I wrote in National Review Online back in December 2000, the question now is, what has the High Court wrought? For example, does a federal cause of action exist if different ballots are used throughout a state? If different methods of voting are used in different counties? Or if different methods of voting are used in different localities within a county? Does a federal cause of action exist if older voting machines are used in poor areas and newer machines are used in affluent areas? Where once federal courts were loath to get involved in elections based on lack of standing and or separation of powers, political question doctrines, federal judicial intervention in state and federal elections may now become commonplace. Litigants will attempt to use the courts to overturn the results of elections. And I go on to give some examples. And let's see. There are several significant questions about the 2000 presidential election that are raised frequently but rarely answered. Could the Florida legislature have intervened and chosen the state's presidential electors itself? Page 169, Men in Black. Yes. Article 2, Section 1, Clause 2 of the U.S. Constitution provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives, to which the state may be entitled in the Congress, but no senator, representative, or person holding an office of trust or profit under the United States shall be appointed an elector. So the Florida legislature could have, and in fact was preparing to intervene and name a slate of electors if the Florida Supreme Court continued to interfere with the election. By the way, as a footnote, when I mentioned the possibility that a state had that power in 2020, Boy, did I come under attack. You remember that, Mr. Producer? Remember all that? The legislature, which was controlled by the Republican Party in 2000, had absolute authority under the Constitution to choose Florida's members of the Electoral College. This is another reason why Gore's litigation strategy was never going to succeed in winning him the Florida electoral votes that he needed to become president. Was it necessary or appropriate for the U.S. Supreme Court to enter the controversy? I believe the Supreme Court intervened in the 2000 election not to choose a winner, but rather to rein in the Florida Supreme Court, which was intent on allowing county election boards to recount returns under increasingly flawed standards until the desired result had been achieved, a victory for Gore. But it was not necessary for the court to become involved at all. The issue would have been resolved on the explicit language of the Constitution by the Florida State Legislature and ultimately the United States Congress. Is there any scenario under which Gore could have won? Both practically and constitutionally, no. There are three basic reasons for this. Ready? First, on November 26, 2000, after Florida's returns had been certified by Katherine Harris, most people didn't know this, we did. Governor Bush sent a certificate of ascertainment, that's what it's called, to the archivist of the United States certifying the election of the Republican slate of electors to the Electoral College as required by federal statute. Once Jeb Bush had done so, no authority, state, federal, legislative, or judicial, could force him to withdraw his certification. You see, ladies and gentlemen, when I was writing about this, we contacted Governor Bush's office and we asked them, or said to them, you know, you have a right to just go ahead and file. And they said, yes, we do, and we did. We said, what? That's right, we did. And we checked it out. And they had. And the media didn't jump on it. Certainly his certification could have been challenged in Congress when the Electoral College votes were counted, but federal law recognizes no other authority who could actually certify Florida's electors or the votes of those electors. I told you, you're going to learn a lot here. Second, once the Electoral College votes were counted in Congress, a challenge of the Florida votes would have required a majority vote in each house to reject Florida's electoral vote, an unlikely scenario as the Republicans controlled the House of Representatives. Even if this hurdle had been jumped, in other words, if there's a conflict, if Gore had gotten the votes in Florida because of what the state Supreme Court was doing, how many times have I told you, we don't have a president until Congress says we have a president, until the electors are counted. And who decides if the votes in the states, that is the Electoral College vote, are to be counted? Congress. Not a federal prosecutor, not a judge. So even if this hurdle had been jumped, the House would then have chosen the president by a vote of the majority of the state delegations. That's the way it works. Since the Republicans outnumbered Democrats in a majority of the state delegations, the Republicans controlled a majority of the delegations in the House of Representatives. I have no doubt they would have voted to uphold the election of George W. Bush. A very unlikely but technical possible scenario of a Democrat winning would have involved the vice presidency, not the presidency. Had a challenge been made, this would be Lieberman. The Senate, which was split 50-50 along party lines, would have selected the vice president by the vote of individual senators. Since Gore was still serving as vice president and therefore president of the Senate, he could have cast the tie-breaking vote for Joe Lieberman. In other words, George Bush was always going to be president, no matter what the Florida Supreme Court did or the U.S. Supreme Court, because Congress has the final say. And it would have been decided by the majority of the state delegations in the House, 27 of which were Republican. The Senate would decide the vice president. The Senate was 50-50. Al Gore was still vice president, hence the president of the Senate. So technically you could have had Bush as president and Lieberman as vice president. But that's how the system works.